segment number 2, which is let's shift things back to the U.S. And an interesting story, there's a press release that came out from MMJ BioPharma yesterday saying that the DEA in a lot of ways has blocked conducting federal compliant research of theirs for over 2,300 days, despite FDA support. And the reason why this got some attention is because the current Attorney General Pam Bondi is also backing a lot of these claims as well. So with that, let's welcome in their CEO, Duane Boise, first time to the podcast. Good to meet you. How are things?
Hey, doing great, Chad, Anthony. Nice to meet you both. Thanks for having me today.
So that was an interesting press release. It grabbed a lot of people in this industry, a lot of attention with the backing of Attorney General Pam Bondi. But first, walk us through, maybe a little bit about your background, what you've been working on, and really a lot of the challenges that you've been facing for, that's a long time. What's 2,300 days? Is that 5, 6, 7 years?
7 years.
Yeah.
And we filed in December of 2018 for the DEA API bulk manufacturing license, which is DEA speak to grow marijuana for pharmaceutical formulation.
Right.
It's been an interesting challenge. So let me just give you the short overview.
Yeah.
3 companies were formed. MMJ International Holdings is the clinical trial study company, which has the INDs with the Food and Drug Administration. MMJ BioPharma Cultivation applied in 2018 to the DEA to grow specific cultivars that we use to develop our active pharmaceutical ingredient. And then MMJ BioPharma Labs, which is the recipient of a DEA Schedule I analytical lab license, which we still have. The interesting note here is that the same team that got the Schedule I license as labs is the same team that's in cultivation, but they didn't give us the Schedule I license as that. So, I mean, the hypocrisy is a mile long here.
Wow.
So how was it, or how was the process getting that DEA testing license? Were you interfacing a lot with them? Were they easy to deal with? Was it very rigorous? How was it obtaining that license?
I can say that the lab license was, it was difficult because you had to meet all the security protocols.
I'm sure.
And you had to meet the regulations to the Controlled Substance Act. A different investigator, they call it a 303 investigation, both for the lab and for the cultivation, came in, and the personalities were so different that, I mean, you could tell that the lack of knowledge was significant on one of the investigators, Tom Cook mainly. His first question, he was doing the API bulk manufacturing or the grow registration. He asked us if we were growing the marijuana in a 10 by 20 vault. So, I mean, that's where it started, and he went progressively downhill pretty quickly.
Wow.
All the way to the point where we are now. So, this is the DEA not training their people properly, and it's just ignorant and biased, and they're being stubborn in this case. But I'm fighting them all the way down on the cultivation license, and we'll eventually succeed.
Now, for context, the bulk cultivation and API license, is that the same thing as the licenses that are currently issued from the DEA with certain institutions or certain universities in the United States where they're doing research currently on cannabinoids? Or
That's
is that
a different license.
It's a different license.
That's a researcher's license, right?
Okay.
That's a different registration. So
who currently has API bulk manufacturing for cannabis in the States?
Well, that was the great scam on behalf of the DEA. So they came out, and all these people invested all sorts of money, one of which being us. There were 6 or 7 registrations issued. Most of those registrations are defunct, out of business, bankrupt, and nobody's growing any pharmaceutical marijuana. So the best example was Royal Emerald. I don't think they filed for bankruptcy protection yet. They went out and purchased a Kmart facility, 100,000 square feet, renovated it into grow rooms, spent a ton of money on the renovation, air conditioning, lights, and so forth and so on. Get it all done. They've applied for the registration. They get the registration. They go to Polaris and take down, 15 or 17 million at 15%. The payments were 178,000 a month. Pick up the phone, CEO calls the DEA in the quota section, and the gal says to him, well, are you doing a clinical trial And the CEO says no. And well, do you have a doctor that needs, 100,000 square feet of marijuana? No. So, well, we can't give you quota. So evidently Royal Emerald was unaware of what the quota requirements are. And in order to meet quota, you would have to have gone about it the way we did. INDs, clinical trials at the Food and Drug Administration,
Right.
Back into the amount of quantity you would need for those clinical trials and eventual approval by the FDA, and that would give you your quota. And that's the way we approached it. So anyhow, the short of it is that they got quota for 20 plants and 100,000 square foot facility.
So what's the holdup here? This has been 7 years now. Have you gotten a clear, concise answer? Because, it's not normally outside of Ann Milgram that we actually hear names, but you've named a few names, which is Matthew Straight and Thomas Prevoznik at the DEA. So what role have they played in this delay? Because that is a long time.
So we knew that we were getting blocked pretty much from the get-go, because every time I called in for a status update, nobody got back to me.
Okay.
The inspection finally started, and then through the course of the inspection, we got very little guidance on what they actually wanted. So I had hired 2 retired DEA agents that were in administration so that they could guide us through the 303 investigation to get an approval.
Okay.
I'm hearing off the record that it's the marijuana bias, because agents have gotten killed in Mexico over this marijuana thing and Ann Milgram, and a couple of people didn't want to let this move forward because of the death of those agents.
Gotcha.
That has nothing to do with helping patients and creating a pharmaceutical drug.
So what do you say in that situation then?
I mean, watch the action, not the speak, I always say, right?
Yeah.
So the action has been consistent obstruction by them to the point that we know they're obstructing it intentionally now. I believe the second part of that intentional obstruction is that they know how much marijuana we need to be growing to get the essence of the fill of those gel caps.
Right.
Now, they could fight us on quota through the clinical trials, but they can't fight us once the FDA approves that, because I need 1 million square feet of grown marijuana.
Gotcha.
To fill potentially billions of pills. And I think that's where the rub is. They don't want this to get out of the box. It's just this.
So right now, but you're in line at the FDA, correct? Because I know one of the drugs is orphan and one of the other drugs is fast tracked.
That's correct. So the orphan designation is significant, and we're focusing on the Huntington's trial, and we're going back and forth with the FDA now.
Okay.
And really, I got to say, they've been very nice to deal with, and they're asking credible questions. The agency has put a CMC hold on our clinical trial because they're asking these very tough chemistry questions and how we've gone about in the consistent reproducibility of this natural drug in a gel cap form.
Correct.
We've responded to all the questions, and now the question comes in where the damages are. They said, do you have enough extract to continue into the quasi-commercialization and use in clinical trials? And the answer was no. I mean,
Right.
The DEA gave us permit to ship out of Canada, where we did all this work. And we shipped into Catalan Pharmaceutical in St. Petersburg, Florida.
Okay.
And then we worked with them for several years on developing the soft gelatin capsule, to the point where we have all that scientific data, stability, and all the other requirements that the FDA asked us to do.
So with the FDA, is the rub right now the fact that let's use Epidiolex as an example? I know that they're using a synthetic CBD in their medication, which enables consistency throughout in terms of the actual molecule. So that obviously passes muster with the FDA. The FDA is rubbed right now is the fact that you want to use natural THC, and they're asking you to prove the consistency.
It's consistent reproducibility of the drug, right? And we have that. But the problem is that the DEA not allowing us to take the THC in and grow it under the API bulk manufacturing license. That's where the rub comes in.
So,
So
have things changed with this new administration? Like, we're seeing reversals from the DOJ. You have support from Attorney General Pam Bondi. We talk about Ann Milgram in the FDA. The DEA in the past. That was a previous administration. So are you seeing any kind of difference since Trump has stepped in? I know Terry Cole is still yet to be confirmed as the head of the DEA, but are you seeing any change since the Trump administration has entered in?
I think the Pam Bondi was significant change, because if you have to understand the agency's administrative law process. And this sort of comes back to the rescheduling issue too. You hire all these high-powered attorneys and they're going into a kangaroo court at the DEA. So if you think about it, the administrative law judge is appointed by Ann Milgram, right? You got the attorneys in the DEA that work for the DOJ, but they're still DEA attorneys.
Yeah.
And so, the cards are stacked against you. So that judge that's doing that hearing in our case and in the rescheduling case could come out and agree with both of us. And then it goes right back to the administrator. The administrator says, I don't like Duane. I don't like rescheduling. No. And that's the end of the story.
Okay.
So now all that data that they've stacked against you and slanted it negatively against you is now of the record. So if you appeal it, you're fighting an uphill battle.
So go finish your thought.
In our case, we stopped that kangaroo court process. I sued him as a violation of our constitutional rights, and I used the Supreme Court Axiom decision and Jarsky's decision, which basically, one was in the FCC and one was, I think, the FAA, and the agencies are similar on how they operate these kangaroo courts. And the court came out and said that it was denying the parties their right to a trial by jury. And
but as per the quote and as per the letter that you had sent me yesterday, correct me if I'm wrong, but didn't AG Bondi or the Solicitor General say that while the stringent laws around the removal of an ALJ are unconstitutional, they agree there, but they're still not willing to remove the ALJ due to the fact that the ALJ has not caused harm to yourself, being the plaintiff, which you admitted in the case as well, as per that letter. Am I not correct?
Yes, you're correct. And that's what the judge in Rhode Island said. So what happened is that they're teaming up against us. They file a motion for the judge to dismiss. What the judge in Rhode Island should have done, we hope that he would have done, was dismiss the case because of Pam Bondi's letter, and then issued an injunction against the DEA from proceeding with the unconstitutional hearing. He didn't do that. And he based his decision on the fact that we didn't show harm. Well, I mean, that just defies logic. I mean, we've been harmed, 7 years waiting. Now we're dealing with having to go to other logistical sources to get the extract for the FDA to continue. So it's just a big gameplay, right? So now the attorneys are drafting, number one, to get an injunction and get the judge recused from the hearing, and then file another federal lawsuit in Rhode Island District for the judge to issue a permanent injunction and to demonstrate how they've harmed us.
Got it.
I mean, what is harm? I mean, we've been waiting 7 years. That's not enough harm.
Yeah.
So what's the end? What is the end game here? Is the end game to
issue us the registration?
Okay.
Well, and in the meantime, I'm hoping to gut the DEA's unconstitutional practice of the way they do business. And this is why they're all fighting for their jobs, right? Because Provoznik's gone, Straight's gone, the attorneys are gone, the judges gone.
Okay. So do you think if there is a shift, and I'm not trying to string things together here, but do you think that if there is a shift when Terry Cole gets into the administrator seat and he reschedules cannabis as a whole from Schedule 1 to Schedule 3, do you think that that frees up the administration to effectively grant your API bulk license?
No,
or are those two events not correlated?
We follow the law to a T.
Okay.
We followed it under the Schedule 1 protocol. So whether they reschedule it or not, it has no bearing on us.
Right.
Okay.
Right. But they're still not doing the right thing under the Schedule 1. Why would we ever think they would do it under Schedule 3? I mean, the Schedule 3 thing is no big win. I mean, I think that, we're one of the very few left standing. And, quite honestly, they're not going to stop us because we're...
What do you mean by Schedule 3 is no big win? Can you elaborate on that a little bit more?
Well, it's still under the Controlled Substance Act. So it actually could be a derogatory effect on these state operators, right? As I watch the action here, Shad, it doesn't look good for the state operators. Trump just removed the protection of the states by funding the legal mechanism to go after it, right? Hasn't been ruled on yet, but that's where it's going. If it is, now the DEA is open to go into the states on potential money laundering issues, potential cartel issues of shipping, potential shipping of, say, a Florida grower into Georgia. That's all in violation of a Schedule I substance and a Schedule III substance. So this isn't looking good for the state-to-state businesses.
But those state businesses, but I mean, that's obviously a big hypothetical. I mean, those state businesses, at least to my knowledge, there's no Florida businesses shipping product into Georgia. If there are, and that is a complete violation of the MMTC program that they're being governed under in the state of Florida, then there is enforcement that is due in that scenario. If there are,
what I'm saying, don't take me out of context. I'm an advocate, but I'm telling you, I'm watching the speak and I'm watching the actions, and it does not.
I agree with you. I agree with you completely, but also at the same time, adding some nuance to it. If there are operators under these state operator frameworks that are acting, that are bad actors, then they deserve to get enforced upon by the federal government. Blanketly coming after them would be one other thing, which is an implication of what you're saying, which you can read between the lines. And yes, reneging those protections does open that up, but it's to be determined if they are going to do that correct as a whole.
So where does Pam Bondi play in this role? Because getting her support, it was crucial. What's the backstory involved in that? Because I'm kind of getting conflicting directions here that you have a support from an attorney general, but yet it's not looking good on the state's level for a lot of these companies. Like, is rescheduling what we think it could be and, wiping out 280E and providing growth for the industry? Like, how do you look at it? And what's this mean, as I said before, what her role is in a lot of this right now?
Well, as far as we're concerned, she said that she wasn't going to defend any constitutional challenges for the Drug Enforcement Administration in our case. I consider that as a win. Yeah. Now we have to go back and prove the harm, and we're in the process of doing that right now. And I believe we'll get the administrative law judge recused. We did the first one, so I have no doubt that the second one will happen also. So this is going to play out, but I would take that action as very positive. Mm-hmm. As it relates to anything else, I have no idea what Terrence Cole is going to do when he takes over as administrator. It's negative from his prior stance. In that hearing, I watched it very attentively. They were picking out the situation in Oklahoma with the Indian tribe, and that they were taking from the tribal property, crossing over into the state lines of Oklahoma, and then elsewhere. And this is just what the DEA wants to enforce. So, you got to watch the action, not the speak.
And as much as I do believe that THC should be completely free of any of this nonsense, if that is happening, that is by definition the DEA's job function. That's correct. to enforce the law around that. Just like if there are legal companies in California, or if there are legal companies in Oklahoma that are backdooring cannabis, crossing state lines, unfortunately, right now in this country, that is illegal. And I'm not against the DEA enforcing that if it cleans up the rest of the industry, and allows for mainstreaming cannabis as a long run goal.
Yeah.
So you're absolutely right, and it's frustrating for us because we've taken the federal route. We never crossed over the line.
I mean, you took the most stringent route.
I took the most stringent route, and we've adhered to it. Now the DEA, by their inaction and bias, is forcing us offshore to get our API so that we can continue with the FDA clinical trials.
Gotcha.